Hi everyone. Let's start with crimes against property. Firstly, who are these persons exempt from criminal liability? According to Article 332 of the Revised Penal Code, no criminal but only civil liability shall result from the commission of the crime of theft, swindling or estafa, or malicious mischief committed or caused mutually by the following persons. First, spouses, ascendants and descendants, or relatives by affinity in the same line. Second, the widowed spouse, with respect to the property which belonged to the deceased spouse before the same shall have passed into the possession of another. And third is brothers and sisters and brothers-in-law and sisters-in-law if living together. The exemption established by this article shall not be applicable to strangers participating in the commission of the crime. So when we talk about Article 332 ng Revised Penal Code, sinasabi dito na there will be no criminal liability but only civil liability. And ano-ano ba yung mga crimes na nakapaloob sa Article 332? Theft, swindling, malicious mischief. So tatlo lang yan. Tapos, sino-sino yung mga taong magiging exempt from criminal liability from committing these three crimes? Number 1, spouses. Number 2, ascendants or descendants. Number 3, relative of affinity with the same line. Number 4, widowed spouse, with respect to the property of the deceased spouse before the same is transmitted to another person. And panglima, brothers and sisters or brothers-in-law, sisters-in-law, provided na living together. Now, in this article, what is exempted from criminal liability are the following crimes if committed. Swindling or estafa in all forms. Theft, including qualified theft. And malicious mischief. Okay? If theft or swindling is complexed with other crime, then the exemption is no longer applied. Why? Because Article 332 provides a list. So what is not included in the list is deemed not to be included in the effects of this provision. Another, when a husband committed theft through falsification against the wife, it is no longer exempted. Kasi nga, complex crime na siya ng theft through falsification. Pero kung simple theft lang, the husband in this case will be exempted from criminal liability. What else? Hindi rin exempted ang estafa through falsification of documents. And in this case, spouses na mentioned sa batas need not be married because the provision also includes common law spouses or common law relationships, no? And last qualifications of brothers and sisters, kasama din yung half-siblings, ha? Kasama din dyan yung step-siblings. Kasama din dyan yung brother-in-law at saka yung sister-in-law. Provided, ang qualification dito is that they must be living together. So, hindi pwede magkaibang bahay, no? Kapag magkasama sa isang bahay, exempted yung mga kapatid or half-kapatid or kinakapatid ninyo. Hindi kasama yung kinakapatid sa 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 binyag. Kailangan brother, step-brother, half-brother, or brother-in-law. Now, meron kayong case dito na yung dekarugkong versus people. So, in this case, certain William, tutulungan ko muna kayo sa first case, no? And then the rest kayo na magbabasa. So, in this case of dekarugkong versus people, William was married to Zenaida, and then they have 2 daughters, Karen and Wendy. Zenaida died ahead of her mother, Manolita, yung mother-in-law ni William. William made Manolita sign special powers of attorney appointing Wendy, then 20 years old, as Manolita's attorney in fact, to sell and dispose 4 valuable pieces of land in Tagaytay City. So yung matanda raw, yung nanay ng asawa ni William, pinapirma niya ng mga papeles na nakalagay doon na ina-appoint ng matanda ni Manolita si Wendy, yung isang anak ni William at saka ni Zenaida, so apo ni Manolita, apo nung pipirma, para i-authorize yung kanyang apo na ibenta yung 4 na pirasong lote niya sa Tagaytay. William told Manolita, who was already completely blind. So, nung panahon na yon, si Manolita, yung pipirma yung lola, ay bulag na. So, sinabi ni William, no asawa nung anak ni Manolita, that the documents she was signing was merely for paying taxes. So, it was only for the purpose of paying taxes according to William. But the true purpose is for selling the subject properties na pinagmamayari nung bulag na matanda. Okay? Believing William's misrepresentation, Manolita signed the documents. Of course, the lola, the mother-in-law of William, in this case Manolita, would somehow, di ba, would trust. So, magtitiwala ka doon sa asawa ng anak mo. So, pumirma siya doon sa mga documents na kunyari ay sa pagbabayad, tungkol lamang sa pagbabayad ng mga buwis. Pumirma siya na hindi niya nalalaman yung totoong nilalaman kasi nga bulag na yung matanda. The parcels of land were sold eventually and William misappropriated the proceeds amounting to 22 million pesos. So, yung 4 na properties na binenta ni William na pinapirma niya, yung bulag niyang mother-in-law, ay nagkakahalaga lahat-lahat ng 4 na subject properties na yon sa 22 million pesos and 34,000. Okay? So, kinamkam lahat yun ni William. After the death of Manolita, one of the surviving daughters filed a petition for the settlement of Manolita's intestate estate before the RTC, praying that she be appointed the administratrix thereof. So, may isa pang anak si Manolita. Nung mamatay si Manolita, nag-request siya sa regional trial court na kung pwede siya mamahala sa mga properties na naiwan ng kanyang inay. After her appointment, she learned from her niece, Wendy, about the fraudulent sale of the parcels of land and the misappropriation committed by William. So, nung na-appoint na si Mediatrix, yung isang anak ni Manolita, nalaman ni Manolita sa kanyang pamangkin, kay Wendy, yung inappoint ni William, na yung tatay niya, si William, ay pinapirma ng ganon yung kanyang lola, yung nanay ni Mediatrix, para ibenta yung mga subject properties ng hindi nalalaman nung matanda. Thus, as the duly appointed administrator of the estate of her deceased mother, Mediatrix filed a case for estafa against her brother-in-law, William. So, kinasuhan ni Mediatrix si William kasi nga nalaman niya eventually yung kalokohang ginawa ng asawa ng kanyang kapatid. William moved to quash the information, claiming that Article 332 of the Revised Penal Code, his relationship to Manolita, his mother-in-law, exempts him from criminal liability. So, sabi naman ni William, ito yung application ng Article 332. So, sabi ni William, teka lang, mother-in-law ko si Manolita. So, hindi ako magiging criminally liable sa pinagbibintang mo sa aking estafa. Bakit? Dahil sabi na ng Article 332 kapag meron daw, kapag mother-in-law, dahil ascendant ko siya, mother-in-law ko siya, exempted ako sa criminal liability. Yan ang contention ngayon ni William. The Regional Trial Court sustained William's motion and dismissed the information. So, sabi ng RTC, oo nga, sige, absuelto si William. However, the court said that the death of Zenaida did not extinguish the relationship, the affinity of her husband William and her mother Manolita, and therefore Article 332 exempts him from criminal liability, and this exemption was still applicable in this case. So sabi nga ng Regional Trial Court, hindi porke namatay na yung matanda, hindi na sila mag-mother-in-law. So kahit namatay yung matanda, exempted pa rin si William kasi son-in-law pa rin siya ni Manolita. Umakyat yung kaso mula sa Regional Trial Court papunta ng Court of Appeals. So sabi ng Court of Appeals, tama yung RTC. Exempted from criminal liability si Manolita. Now, the case reached the Supreme Court. Kaya siya naging jurisprudence, no? So, ang issue ngayon, nung makarating yung kaso sa Supreme Court ay whether or not William should be exempt from criminal liability for reason of his relationship to Manolita. So, tama nga lang ba na ma-exempt si William under Article 332 dahil siya ay son-in-law ni Manolita? Ngayon, sabi ng Supreme Court dito, mali ang Court of Appeals, mali ang Regional Trial Court. With this issue at hand, the Supreme Court answered in the negative. Sabi ng Supreme Court, the coverage of Article 332 is strictly limited to the felonies mentioned therein. The unmistakable language of the provision shows that it applies exclusively to the simple crimes of theft, swindling, and malicious mischief. It does not apply to cases not explicitly mentioned by the said provision. Tulad ng sabi ko sa inyo kanina, kailangan theft lang, or swindling lang, or malicious mischief lang. Eh sir, ang final lang naman kaso kay William ay simple theft, diba? So dapat, dahil swindling is equal to theft, so dapat na exempted siya. Ito yung sabi ng Supreme Court. A reading of the facts alleged in the information reveals that William is being charged not with simple estafa, but with the complex crime of estafa through falsification of public documents. Sabi ng Supreme Court, hindi simple estafa ang kaso ni William, bagkus estafa through falsification of public documents. The crime of estafa is different. The crime of simple estafa is different from the complex crime of estafa through falsification of public documents. Now, this crime of estafa through falsification of public documents is not anymore included in the list of exceptions under the Revised Penal Code, specifically Article 332. Meaning, sabi ng Supreme Court, the purpose of Article 332 is to preserve family harmony and obviate scandal. Thus, the action provided under the said provision simply concerns the private relations of the parties as family members. But when estafa is committed through falsification of a public document, the matter acquires a very serious public dimension and goes beyond the respective rights and liabilities of family members amongst themselves. Effectively, in this case, William the accused cannot anymore avail of the beneficial application of Article 332, considering that the crime he committed falls under the nature of a complex crime, which is the crime of estafa through falsification of public document, and not the simple crime of estafa, which is included in Article 332. Hence, he can be criminally liable. Yan ang ruling ng Supreme Court sa kaso na to. Okay? A stringent application of the provisions of Article 332. Gets? Okay, yan lang case I discuss ko. Yung mga cases na iba, you should read it in their entirety. Okay? Tinulungan ko lang kayong mag-digest ng case, maintindihan yung first case. Okay? Theft, let's now go to theft and robbery rather. No? So what constitutes theft? Sabi ng Article 308 ng Revised Penal Code, theft is committed by any person who, with intent to gain, but without violence against or intimidation of persons nor force upon things, shall take personal property of another without the latter's consent. Okay. So, yan yung definition ng liability for theft according to Article 308 of the Revised Penal Code. Okay. However, the crime of theft has 5 requisites. Okay. First requisite thereof, that there must be taking of the personal property of another. Second is that the said subject property belongs to another. Third is that the taking be done with intent to gain. Fourth is that the taking be done without the consent of the owner. And fifth is that the taking be accomplished without the use of violence against or intimidation of persons or force upon things. Okay, yan yung general requisites or elements of the crime of theft. So what constitutes theft? Yan yung requisites at yan yung definition provided ng batas, no? However, the crime of theft is also committed through the following means. First, by any person who, having found lost property, shall fail to deliver the same to the local authorities or to its owner. Ito interesting, no? You are liable for theft for not returning to the owner his or her property, or you are liable for theft for not surrendering to proper authorities any lost or stolen property or property which is not yours. Okay? Second, theft is also committed by any person who, having maliciously damaged the property of another, shall remove or make use of the fruits or object of the damage caused by him. So dito naman, malapit-lapit siya sa malicious mischief, no? So aralin nyo rin yan. So in this case, sabi after having maliciously damaged the property of another. So mainis ka, may galit ka, or trip mo lang, intention mong sirain o manira ng gamit ng iba, you will also be liable for theft if after mong manira o sirain ang gamit ng iba, ay you will remove or make use of the fruits or object of the damage you caused. Yan. Pangatlo, theft is also committed by any person who shall enter an enclosed state or a field where trespass is forbidden or which belongs to another, and without the consent of the owner shall hunt or fish upon the same or shall gather cereals or other forest or farm products. Siyempre, di ba? Sa isang lugar na hindi ka maaaring pumunta dahil hindi mo pag-aari o wala kang permiso mula sa may-ari. Tapos kumuha ka doon ng farm products, naghunt ka ng hayop or ng isda ka, kumuha ka ng bunga, ng puno, o ng mga tanim. Of course, that is tantamount to theft. Okay? Second question, what is asportation? Sabi dyan, no? So asportation means carrying away. To learn more about asportation, you have to read the case of Medina versus People. Nandyan yan sa syllabus. Next, how about the ability to dispose? What do we mean by the ability to dispose? The ability to dispose means the ability of an accused to freely get away of the item stolen at the time of the apprehension. So, to learn more, read your case of Valenzuela versus People. Next, what is knowledge of the owner of the lost property? Knowledge of the owner of the lost property means that the accused must have known that the lost or stolen property did not belong to him and that he must have known to whom it did belong. So to learn more about that, read Gaviola versus People. And then, the last question there is, are these elements of theft? So let's answer this. Is asportation an element of theft? Kung nakinig kayo kanina sa Article 308, na sinabi ko, asportation is not an element of theft. Kasi sabi dito, sa Medina versus People, asportation means carrying away. So matututunan nyo sa Medina versus People na hindi kailangan na madadala yung gamit para masabi mong consummated yung crime of theft. For example, nasa showroom ka ng Toyota. Tapos gusto mo sanang nakawin yung battery nung ano bang pinakamalaking sasakyan doon, halimbawa yung battery ng Toyota Fortuner. It so happened na injured yung dominant hand mo. So habang nakatalikod yung mga tao doon sa dealer, may tools kang dala, binaklas mo yung battery, binaklas mo yung terminals ng battery rather, tapos caught in the act ka na bibit-bitin mo, tatanggalin mo na yung battery mula sa sasakyan, bubuhatin mo na siya. Sabihin mo ngayon, this is not the crime of theft because there is this concept of asportation, meaning I have to carry it away. E tignan nyo nga, injured yung left hand ko or yung right hand ko. So hindi ko siya madadala. So hindi to crime of theft. Now, anong sabi ng Supreme Court dyan? So basahin yung Medina versus People. Sabi ng Supreme Court dyan, asportation is not an element of theft. Kahit hindi mo yan kayang madala agad-agad. If there is intent to gain, if there is taking of personal property, if it belongs to another, if it is without the consent of the owner, and if it is done without violence or force upon things, that is theft. Okay? Next, is the ability to dispose an element of theft. So sabi sa case ng Valenzuela versus People, basahin niyo yan. The ability of an accused to freely get away of the items stolen at the time of apprehension is not an element of theft. Okay? Halimbawa, bigyan natin ng mas malaking example. Halimbawa, nasa furniture shop ka. So, hindi porke hindi mo kayang buhatin yung cabinet doon, pero kahit halata namang binabaklas mo na at ilalabas mo na, hindi porke hindi mo kayang buhatin mag-isa yun, ay hindi na yun theft, no? So sabi ng kaso na yan, the ability to dispose is not an element of theft. Basahin nyo. Next, is knowledge of the owner of the lost property an element of theft? Hindi rin. So kahit hindi mo kilala yung may-ari, liable ka for theft. Hindi mo pwedeng sabihin, ay akin na lang tong cellphone na naiwan sa classroom. Wala namang wallpaper. Hindi ko na alam kung teacher may-ari nito, kaklase ko, wala namang pangalan. Wala ring tumatawag. Wala ring case. Wala pala tandaan kung sino to. Hindi ko alam kung sino may-ari. So, pwede ko na itong kunin. That's wrong. Okay? Sabi ng Gaviola versus People, basahin nyo, hindi porke hindi mo alam kung sino may-ari. At kinuha mo yan, absuelto ka na. Liable ka pa rin for theft. Okay? May bonus akong concept dito, no? So, pag nabanggit sa inyo ano yung animus loquendi, sabihin nilang attorney, animus loquendi is the intent to gain. Intent to gain. It is an internal act that is presumed from the unlawful taking by the offender of the thing suspected of theft. Okay? Next question dyan. Will there be theft if the accused only has constructive possession? The answer is yes. However, let us differentiate concepts, no? There is this thing as physical, actual, or material possession. Pare-pares lang yan. Versus constructive possession. Let us define yung first. Physical or actual or material possession exists when a thing is in the immediate physical possession or control of the accused. Pinakamadali. Ano tong physical possession? Hawak mo. Nasa iyo. Okay? Nakita sa bag mo. That is physical, actual, material possession. Nasa bulsa mo. Nasa kamay mo. Next is constructive possession. Constructive possession exists when a thing is under the dominion and control of the accused or when he has the right to exercise dominion and control over the place where it is found. So, mas malalim-lalim yung constructive possession, no? So, hindi lang basta hawak mo. Hindi lang basta nasa bulsa mo. Kundi, maaaring ginagamit mo, kaya mong gamitin, kaya mong buksan, kaya mong hawakan, kaya mong buhatin. Any of the faculties wherein you have the right to exercise control. Okay? Pwede mong bulsa. Ayun yung constructive possession, no? Hindi lang siya mere actual or physical possession. So, dun sa tanong, will there be theft if the accused only has constructive possession? Definitely yes. Constructive possession of the thief of the property is enough to constitute theft. Sabi yan sa kaso ng Laurel versus Aprugar. Nasa case list nyo rin yan, no? Basahin. There is taking of personal property and theft is consummated when the offender unlawfully acquires possession of personal property even if for a short time. Okay? Sabi nga kanina, ability to dispose is not an element of theft. or if such property is under the dominion and control of the thief. Hawak na yung susi, yan, ano pa, napa-start na yung sasakyan, yan, mga ano yan, indications yan ng constructive possession, no? The taker, at some particular amount, must have obtained complete and absolute possession and control of the property adverse to the rights of the owner or the lawful possessor thereof. It is not necessary that the property be actually carried away out of the physical possession of the lawful possessor, or that he should have made his escape with it. Neither asportation nor actual manual possession of property is required. So hindi kailangan na kaya mo siyang iuwi bago ka maging liable for theft. Physical possession, constructive possession, lahat yan basta intent to gain is presumed sa isang unlawful taking, no? What is unlawful taking? Taking of a property which is not yours. So when you take personal property which is not yours, without the consent of the owner, without imploring violence or intimidation against persons or force upon things, yan yung papasok na agad yung theft. Okay? Another bonus, animus possidendi. So pag tinanong sa inyo yan, sir, it is the intent to possess. Next question dyan, must there be actual gain to consummate the crime of theft? Sabi ng Supreme Court sa People versus Papa, basahin nyo rin yan, nandyan yan. It is of no moment that there was real or actual gain. The important consideration is that there was an intent to gain. It is one of the essential elements of theft. So sabi ng Supreme Court sa kaso ng People versus Papa, hindi kailangan may real gain, hindi kailangan may actual gain. Sabi ng Supreme Court, ang kailangan lang ay may intent to gain. Okay? Basahin yung kaso na yan, baka tanong sa inyo. Basta binibigay ko lang sa inyo yung mga rulings in connection to the questions, in connection to the cases. Okay? But the labor of reading the cases, digesting them, understanding them, knowing their facts, being students, those should be your responsibilities. Next question. Who are the persons considered a finder of lost property? Okay? So makikita nyo yan sa People versus Avila. Andyan din yan sa case list. Okay? Dalawa kasi yan. Meron tayong tinatawag sa batas na finder in fact and finder in law. Sir, what is this finder in fact? Finder in fact is one who failed to return a thing despite knowledge that it was lost property. Or a person merely entrusted custody thereof by someone who had no intention to appropriate the same. Ano ang pinagkaiba niyan, sir, sa finder in fact? Finder in fact, mas madali itong intindihin. Okay? So, pag sinabi natin finder in fact, it is the actual finder of the lost property. Okay? So, kung sino yung nakakita, siya yung finder in fact. Sir, kailan naman nagkakaroon ng finder in law? For example, si person A yung nakakuha ng cellphone, pero binigay niya to kay person B. Sino doon yung finder in fact? Si person A. Sino doon yung finder in law? Si person B. Lalo kung hindi alam ni person B na hindi sa kanya yung property at hindi niya sinulit. So, si person B ay liable din for theft kahit hindi siya yung kumuha, kahit hindi siya yung finder in fact, because he failed to return a property which is not his, which is not hers. Okay? Sabi ng Supreme Court sa People versus Avila, pakibasa niyan, Article 308, Paragraph 1 is not limited to the actual finder or the finder in fact. It may include a policeman to whom it is entrusted or misappropriated the same, or a finder in law. Okay. Next question dyan. Can a person steal an intangible property? I don't know kung magiging okay sa professor, but if I'm asked this question, my answer is it depends. It depends on the kind of the intangible property. Anong ibig kong sabihin? Because the general rule is that only movable properties which have physical or material existence and susceptible of occupation by another are proper objects of theft. Intangible properties such as rights and ideas are not subject of theft because they cannot be physically taken from the place it is found and is occupied or appropriated. A naked right existing merely in contemplation of law, although it may be very valuable to the person who is entitled to exercise it, is not the subject of theft. Okay? Such rights or interests are intangible and cannot be taken by another kasi nga abstract sila tulad ng ideas, di ba? Tulad ng rights. At intangible yung mga yan. So, hindi sila proper objects of theft as a general rule kasi hindi sila pwedeng, it cannot be taken by another. Okay? Thus, the right to produce oil, goodwill, or an interest in business, or the right to engage in business, and credit line, for example, cannot be proper subjects of theft. However, ito na yung pumapasok yung sabi ko, it depends, diba? However, intangible properties such as electrical energy and gas are proper objects of theft. Why? The reason for this is that gas or electricity are capable of appropriation by another than the owner. Gas and electrical energy may be taken, carried away, and appropriated. Ito yung sabi ko kanina, di ba? Electricity, like gas, may be seen and felt. They are valuable articles of merchandise bought and sold, like other personal property, and is capable of appropriation by another. Okay? So, paano nyo sasagutin itong tanong ito? Can a person steal an intangible property? It depends. It depends upon the nature or the kind of the intangible property. Because as a general rule, intangible properties cannot be subject of theft. Only movable properties which have physical or material existence and susceptible of occupation by another are proper objects of theft. However, if the intangible property is capable of occupation by another, capable of appropriation by another, when the intangible property is capable of appropriation or ano yung sabi kong word kanina? Or occupation by another, only then can an intangible property be a subject of theft. For example, electricity and gas. Next question dyan. How does theft become qualified? Okay, so makikita niyo sa Article 310 ng Revised Penal Code. Makikita niyo doon qualified theft. Sabi doon, ang qualified theft ay merong 4 na pagkakataon kung kailan mako-qualify yung theft papuntang qualified theft. 4 na instances. Una, when it is committed by a domestic servant. Kasambahay, boy, katulong, yan. Yan, sila yon. Sila biyaya, ganyan. Yan yung mga domestic servant. Okay? Next, when it is committed with grave abuse of confidence. So, the abuse of confidence must be grave. Okay? So, medyo mas malalim siya kaysa sa normal abuse of confidence. Or, when the property stolen is a motor vehicle, male matter, large cattle, coconut from the premises of a plantation, or fish from a fish pond or fishery. So, itong motor vehicle dito, hindi kasama dito yung mga sasakyan. Bakit? Kasi meron tayong anti-carnapping law. Okay? So, yung mga sasakyan sa anti-carnapping law yun papasok. Sir, bakit sabi sa Article 310 magiging qualified theft? Maka-qualify ang theft kapag motor vehicle ang stolen. Yung mga ibang motor vehicle, tulad ng ginagamit sa construction, tractor, ginagamit sa agriculture, yung mga ganun, no? Pison, yan. Pero yung mga motor vehicles, yan ay sakop ng anti-carnapping law. Okay? So, the rest is self-explanatory. And the last is, when the property is taken on the occasion of fire, earthquake, typhoon, volcanic eruption, or any other calamity, vehicular accident, or civil disturbance. So, kapag nagnakaw ka sa panahon ng lindol, sunog, tsunami, pagsabog ng bulkan, bagyo, banggaan, yan, magiging qualified theft yan. No? So, for example, motor versus bike, kabanggaan, may isang passerby, kinuha yung cellphone nung nagkabanggaan, yung mga cellphone nung nagkabanggaan para ibenta, nahuli siya eventually. What's the crime committed? It's not just theft, but qualified theft. Okay? Si kasambahay, nagnakaw ng 20,000 sa envelope na naiwan lang ng kanyang amo. What is the crime committed? Not just theft, but qualified theft because it is committed by a domestic servant. Okay? Ganoon dito sa mga coconuts, fish from a fish pond, lahat yan magiging qualified theft. Sir, ano ba pinagkaiba ng theft sa qualified theft? Bakit kailangan pa i-differentiate? Because the penalties for qualified theft are 2 degrees higher than those in theft. Okay? So, 2 degrees higher. Layo yun in terms of prison time, in terms of service of sentence sa mga possible convictions. Okay? May isa pa palang tanong dyan. Is employer-employee relationship essential to qualify the crime of theft? The answer is no. The answer is no. Mababasa niyan sa People versus Serranilla. Nandiyan din yan. Sabi ng Supreme Court sa kaso na yan, the fact that the offended party, which is the owner of the stolen property, is not the employer rather of the accused, is of no moment, is of no merit. The relation of independence, guardianship, or vigilance between the accused and the offended party makes the offense that of qualified theft. Meaning, sabi ng Supreme Court sa kaso na yan, employer-employee relationship is not essential to qualified theft. Okay? Next question. In what instances will the physical taking of a personal property without owner's permission become robbery? So, ito na siguro yung papa-differentiate sa inyo dito, yung theft versus robbery. No, kailan daw, yung pagnanakaw ay hindi lamang theft, bagkus ay nagiging robbery. Okay? So, basahin niyo, mababasa niyan sa Article 293 ng Revised Penal Code. So, sabi doon, Persons who are guilty of robbery is any person rather who, with intent to gain, shall take any personal property belonging to another by means of violence or intimidation of any person or using force upon anything or use upon anything. So, anong pinagkaiba ng theft at robbery? Parehas namang may unlawful taking, parehas may intent to gain, parehas taking of property of another, parehas without the consent of another. Anong pinagkaiba, sir? Ang pinagkaiba dun sa last requisite, dun sa last element, no? Because in robbery, there is violence against or intimidation of persons or use of force upon things. Walang use of force upon things, walang intimidation of persons, walang violence against persons sa crime of theft. Which is why, kapag dinukot yung cellphone mo mula sa pantalon mo, ang crime doon ay theft. Pero kung tinutukan ka ng balisong para ibigay mo yung cellphone mo, that is called robbery. Okay? Kasi may intimidation of persons. Samantalang doon sa dinukot lang sa pantalon mo, nang hindi ka tinutukan, walang intimidation of persons. So, theft lang siya. Okay? Yan yung differentiation nilang dalawa. Next question, what are the stages of robbery? Okay? So, there is attempted robbery and consummated robbery. So, nakapag-crime 1 na kayo, I assume na alam nyo na yung stages of execution. So, attempted, frustrated, tapos consummated. However, in the case of robbery, or simple robbery, attempted lang at consummated. Okay? Nandiyan din yan sa case list nyo. Sabi ng Supreme Court sa People versus Barra, there is attempted robbery when the robber, magnanakaw, commenced the commission of robbery directly by overt acts and did not perform all the acts of execution which would produce robbery by reason of some causes or accident other than his own spontaneous desistance. Yan, attempted robbery lang. Kapag hindi natuloy, hindi na consummate yung robbery, hindi nakuha yung gusto niyang kunin, okay? Attempted robbery. Pinutukan ka, hindi ka naman sinaksak, nakatakbo ka, attempted robbery. Kasi sinubukan niyang nakawan ka. Okay? Whereas kung tinutukan ka, natakot ka, labot mo yung cellphone mo, consummated robbery. Sabi ng Supreme Court, nasa case list niyan, sa People versus Salvilla, robbery is consummated when the robber acquires possession of the property even if for a short time. Kahit nakuha niya agad yung cellphone mo dahil natakot ka na, tinutukan ka ng ice pick, tapos pinasa niya agad sa kanyang kasabuhat sa isang lugar, sa isang iskilitang madilim, yung nanutok sa'yo, yung pinag-abutan mo, kahit 10 seconds lang pinasa niya na, liable siya agad pa rin for the crime of consummated robbery. Okay? Next question, what distinguishes robbery from simple theft and qualified theft? Ito, balikan nyo na lang, na-discuss ko na lahat yan. So, what distinguishes them? Simple theft, differentiation of robbery sa simple theft, ang robbery ay may use of force upon things or violence against person or intimidation of persons. Pinagkaiba ng simple at qualified theft. Yung qualified theft may mga qualifications. 4 yun. Diba? Ginawa ng domestic servants, ginawa with grave abuse of confidence, ginawa sa typhoon, any other calamity, earthquake, fire, etc. etc. Or kapag mail matter, motor vehicle, large cattle, coconut fish from fish pond. Yun. So yun yung mga qualifications. So yun lang. Pag distinguish sa inyo, sabihin nyo lang, simple theft is committed under Article 308 by the following requisites. Qualified theft is committed by qualifying the crime of theft from Article 308, including one instance which is included in Article 310. Next, there is robbery when there is unlawful taking, intent to gain property of another without the consent of another with use of force upon things or intimidation of persons or violence against persons. Yung ganun lang siya, sagutin, okay? In what instances will robbery become special complex crime? Ito medyo malalim na to, pero pwede pa rin naman sagutin para mabilid sa inyo lalo, no? Meron tayong tinatawag na robbery with homicide. Kapag may namatay, on the occasion of robbery with homicide. Meron din tayong robbery with serious physical injuries. Siyempre, pag hindi namatay, sinaksak pero hindi namatay, nabuhay, pero malala, robbery with serious physical injuries. Robbery with rape, yan. Hindi lang basta ninakawan. Okay? Ginahasa din. Robbery with rape. Next, robbery with arson. Hindi lang basta ninakawan, nanunog pa ng property ng iba. Okay? Yan yung instances when robbery will become special complex crime. 4 siya na, robbery with homicide, Robbery with serious physical injuries, namatay, hindi namatay, pero malala. Robbery with rape, alam niyo na yun. Robbery with arson, panununog. Next question. In what way does brigandage differ from ordinary robbery committed on a highway? Ito, para maintindihan nyo, medyo malalim siya. Makibasa, nandiyan din sa case list nyo, people versus puno. People versus puno. Pero sige, bigay ko sa inyo yung ruling ng Supreme Court. No? Sabi dyan, sa case na yan, the main object of the brigandage law is to prevent the formation of bands of robbers. The heart of the offense consists in the formation of a band by more than 3 armed persons for the purpose indicated in Article 306. Such formation is sufficient to constitute a violation of Article 306. Tama. It would not be necessary to show in a prosecution under it that a member or members of the band actually committed robbery or kidnapping or any other purpose attainable by violent means. The crime is proven when the organization and the purpose of the band are shown to be such as contemplated by Article 306. Yan yung brigandage. On the other hand, ordinary robbery committed on a highway. Okay. On the other hand, if robbery is committed by a band whose members were not primarily organized for the purpose of committing robbery or kidnapping, the crime would not be brigandage but only robbery. Simply because robbery was committed by a band of more than 3 armed persons, it would not follow that it was committed by a band of brigands. Okay, hindi laging brigand, hindi automatic brigandage, magiging robbery siya in this case. Because the purpose of brigandage is indiscriminate highway robbery. Because if the purpose if the purpose is only a particular robbery, then the crime is only robbery or robbery by a band if there are at least 4 armed participants, no? So hindi automatic brigandage. Maaring if the purpose is only a particular robbery, so merong gustong pagnakawan, robbery. Pero kung 4 armed malefactors sila, 4 armed persons, robbery in a band. It is not automatically brigandage because the very purpose of brigandage is indiscriminate highway robbery. Okay? So yun yung pinagkaiba nun. Para mas maintindihan niyo yung kaso, pakibasa, people versus puno. Nandiyan yung citation sa syllabus. Next, what is the crime committed if the property stolen is not personal property? So makikita niyan sa Revised Penal Code, Article 312. Ang basa dyan, yan yung occupation of real property or usurpation of real rights in property. Okay? It is committed by any person who, by means of violence against or intimidation of persons, shall take possession of any real property or shall usurp any real rights in property belonging to another. Yan. So ano-ano ba yung punishable acts dito sa occupation of real property or usurpation of real rights in property? Una, taking possession of any real property belonging to another. How? By means of violence against or intimidation of persons. Taking possession of any real property belonging to another. Pasok yan sa 312. Ano pa? Usurping any real rights in property belonging to another. How? By means of violence against or intimidation of persons din. Pasok yan sa 312. Yan yung dalawang punishable acts under Article 312. May mga requisites yan. No? First, that the offender takes possession of any real property or usurps any real rights in property, kasi nga dalawang instances yon. Second requisite, that the real property or real rights belongs to another, of course. Third, is that violence against or intimidation of persons is used by the offender in either occupying the real property or usurping the real rights or usurping the real property. And lastly, there is intent to gain. So for example, itanong man sa inyo o hindi, no? If the offender had occupied the real property through violence and intimidation, and as a result thereof, namatay yung may-ari ng lupa. For example, no, nasa Negros Oriental tayo, no? So, hot issue yan ngayon. For example, si person A had occupied the real property of person B through violence and intimidation. And however, as a result thereof, napatay niya si person B. What is the crime committed? The crime committed is not murder, nor is it homicide, nor is it theft, nor is it robbery, nor is it robbery with homicide. Sir, what is the crime committed? The crime committed is only occupation of real property. Itong 312. However, two-tiered penalty siya, so mapaparusahan siya sa penalty ng murder or homicide kung ano yung higher na mapatutunayan sa prosecution. Pero ang crime na tawag doon ay occupation of real property. There can be no separate charge of murder or homicide in that case. Okay? So second to the last question, sabi dyan, differentiate real property from personal property. So ang real property, ito, segue tayo sa ibang batas, no? Labas tayo sa Revised Penal Code. Ang real property, sabi ng New Civil Code, ay yung immovable property. Meaning yung real property, yung, di ba, immovable, common sense naman, hindi mo pwede magalaw. Ano pwedeng hindi mo magalaw? Manila Zoo. Oh, personal property by, real property ba yun? Yes, because it is immovable. Ano naman yung personal property? Personal property, sabi rin ng New Civil Code, yun yung mga movable property. Ano yun? Cellphone. iPhone 14 Pro Max. Movable, immovable. Sir, paano naman yung mga iPhone na nasa mall, na nasa Power Mac, sa SM South Mall, sa SM Bacoor, na nakatali, tapos pag nilabas mo, na mag-a-alarm. Di ba immovable din yun? Anong sagot? Sagot, pilosopo ka nun. That is still movable property. Di pag may dala kang gunting, di ba wire lang yun na mag-a-alarm? Gupitin mo, makakatakbo ka. That is still personal property because it is still movable. However, mataas yung certainty na mahuhuli ka. Hindi ibig sabihin na mataas yung certainty na mahuhuli ka. Immovable na siya. Kailangan it is immovable by nature. Buildings, diba? Houses, condominiums, parks, etc. etc. So, nandun yan sa Article 415, 416, 417 ng New Civil Code. Okay? So, last question. Sagutin natin. Sorry. Distinguish occupation of real property or usurpation of real rights in property. Yung diniscuss ko kanina, Article 312 versus altering boundaries or landmarks. Ito naman yung kasunod, Article 313. Revised Penal Code na ulit tayo ha. Na-discuss ko na yung 312. So, discuss ko na lang ngayon yung Article 313. Article 313 or altering boundaries or landmarks has two elements. First, that there are boundary marks or monuments of towns, provinces, or estates, or any other marks intended to designate the boundaries of the same, and that the offender alters said boundary marks. Okay? So dito, hindi kailangan may intent to gain. Yun yung number one difference nila. So pwedeng trip mo lang, okay? Dun sa occupation of real right or usurpation of real property or usurpation of real rights, kailangan may intent to gain. So number one differentiation, you can never go wrong. Pag pinadifferentiate sa inyo, yung 312 tsaka 313, sabihin nyo agad sa 312 may intent to gain, sa 313 walang intent to gain, hindi kayo pwedeng malian. Okay? Because there is no intent to gain in 313. Pag sinabi natin alter, sir, ano sabihin ng alter? Any alteration of boundary marks is enough to constitute the material element of the crime. Destruction of a stone monument or taking it to another place or removing a fence is altering. Okay? Pag may kinuha ka, pag may binago ka, pag may sinira ka, na boundary marks or monuments or any other marks intended to designate the boundaries ng mga yon, tapos inalter mo, paano sinira mo, pinalitan mo, kinuha mo, ginulo mo, ano ba, pinalitan mo, yung mga ganon. So yan yung altering boundaries or landmarks. Well, hindi kailangan ng intent to gain, kahit wala ka mapapala, kahit trip mo lang, kahit inutusan ka lang na gawin yun, na trip lang ng mga barkada mo, liable ka na. So yan yung first part nyo. Yan yun. Yan yung crimes against property nyo. Kasi yung sunod nyo na ay... Kasi yung sunod nyo na ay... okay. Meron pa pala ibang crimes against property tulad ng estafa. Pero okay. So... Ay, hindi. Ay, oo nga. Okay. So, yan. Dyan lang muna tayo. So, maraming nakalagay dyan na read and prepare for graded recitation na cases, no? Reading cases are difficult and time consuming. However, if it's really a need, depending on the professor, and if you really want to fully comprehend and to better understand the provisions of the law and their elements, for example, sa criminal law, mas maigi that you read the case in their entirety sa full text. Pwede nyo gamitin yung lawfill, lawfill.com. Tapos type nyo dyan yung, i-copy paste nyo na lang or i-type nyo yung citation. Pag sinabi natin citation, yan yung GR number. Or pwede rin yung case name. Basta make sure nyo na yung binabasa nyong kaso o yung tinype nyo o yung pinindot nyo ay yung mismong kaso na nasa citation. Kasi for example, maraming kaso ng Santos versus People versus Santos, maraming ganon. Make sure na yung binabasa mong Santos versus People na nasa screen mo, na nasa phone mo, na nasa gadget mo, ay yun mismong GR number nung nakalagay sa syllabus. Okay? So, kung gusto mo mag-digest ng mga kaso, pinarecite ka ng kaso, nang hindi nagtatanong, meron kasi minsan may mga professors na, what is the ruling in this case? Ruling lang kailangan mo. Pag sinabi natin ruling, sir, ano yung ruling? Ano yung final decision ng Supreme Court? Usually makikita mo yan sa latter part. Okay? Nag-agree ba yung Supreme Court sa Court of Appeals? Nag-agree o hindi ba siya nag-agree sa Court of Appeals? Sinabi niya bang acquitted? Sinabi niya bang convicted? Ganon. Okay? Sinabi niya bang present lahat ng elements? Sinabi niya bang absent yung isang element ng theft? Sinabi ba niyang walang robbery? Sinabi ba niyang may robbery? Yun yung ruling pag sinabi ng professor na what is the ruling in this case. Pag sinabi naman ng professor niya na what is the issue in this case, meaning ano yung bread and butter, ano yung mainit na usapin sa kaso na yon. For example, an issue can be, for example, whether or not there was theft, whether or not there was robbery, whether or not it was only theft and not robbery, whether or not all the elements of robbery are present, whether or not alteration is present, whether or not there was intent to gain. Yan yung mga issues. Kasi i-resolve mo yun. For example, the issue is whether theft or robbery is committed. So magkakaroon ng ruling ka dapat ng Supreme Court, robbery is committed, not theft. Or theft is committed, not robbery. Because, blah, 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 blah. For example, issue, whether robbery is committed or theft. Ruling, robbery is committed. Why? Because there was violence against or intimidation upon persons or use of force upon things. For example, issue, whether theft is committed or robbery. Ruling, theft only. Why? Because there was no violence against persons, there was no intimidation of persons, there was no use of force upon things. So it is only theft. Yan, yun yung issue tsaka yung ruling. Kung sinabi naman sa inyo na what are the facts, basic yun. Ano yung nangyari? So, ano yung nangyari? Kwento nyo. Kaya kailangan, sa pagbabasa ng kaso, interesado ka sa kwento. No? Ano nangyari? Huwag mo na sabihin yung mga hindi mahalagang bagay na nangyari. No? Sabihin mo na lang ano nangyari. Paano nag-lead yung kaso papunta doon sa tanong kung meron bang theft or robbery. So, siyempre, banggitin mo yung pangalan ng bida, yung nangyari sa bida, ano yung gamit niya, sino yung kumuha ng gamit niya, anong ginawa para kunin yung gamit niya, tapos makakapunta ka na doon sa issue, makakapunta ka na doon sa ruling. Okay? So yun, message nyo lang ako kapag may ibang tanong. So yun yung may tutulong ko sa inyo sa theft, robbery, tapos occupation of real property or usurpation of real property or real rights, theft, robbery. Yan. So, I guess na-discuss ko naman ng maayos yung mga gusto kong itulong sa inyo. The rest is on you. You read the cases. Lalo't lalo kung ang style ng professor ay discuss the case. So you really need to know the case. Really need to read the case. Tapos yung nakalagay dito, memorize, no? So may mga provisions na pinapa-memorize sa inyo. So tips sa memorization, try nyo mag-mnemonics. So sa mga elements, kung gusto nyo lagyan ng mga letters, tatandaan nyo, intent to gain, well, I. Tapos unlawful taking, you. Yun, yung mga ganun, lagyan mo sila ng mnemonics, no? Yung abbreviations, parang ganun. Pag memorization, kanya-kanya tayong diskarte sa memorization, pero yun yung isang tip po sa inyo, no? Lagyan nyo sila ng mnemonics. Tapos pagdating sa reading cases, yun, kailangan interesado kayo sa kwento. Tapos kailangan nagno-notes kayo, mabinabasa nyo sa phone or sa iPad, ganyan. Sa tablet, ganyan. Sa computer, desktop, laptop, ganyan. Gawa kayo ng notes. Kasi pag doon mo lang babasahin, tapos masyadong marami yung cases, lilimutan mo siya. Okay, so yun lang naman sa ngayon. So parang hindi umabot ng 1 hour yung video natin. Good luck for your next meeting. Use the English language as much as possible. Nagtatagalog lang ako ngayon to help you better understand the provisions of the law and the rulings of the court in the cases and various terminologies. But when you answer your professor, it should be in English because it is the language of the law. No? Unfortunately, English is the language of the law as of now. No? And then, yun, good luck. And update me if this is beneficial. And I hope and pray that this will help you a lot. I hope and pray that you will use this to your advantage, not to cheat, but to help you, no, better understand the concepts in preparation for your recitations, revalidas, and exams. Okay? So good luck everyone. Before this video reaches 1 hour, I'll say goodbye. Feel free to message me in Facebook or Messenger. They're my name, Lester Del Castillo. No? So on my free time, I'll answer you. Okay? So for now, that's all. Replay this video kung gusto nyong mas maintindihan, no? So kung hindi pa nakapag-like, share, subscribe sa channel natin. This is anyways for academic purposes, no? So feel free to do so and feel free to invite your friends to subscribe also. Bukod sa pag-like ng video na to, subscribe din kayo sa channel natin para mas marami tayong matulungan. Eventually, pag makatapos na ako, no, I'll help everyone with concepts na confident akong alam ko at makakatulong sa mga estudyante at sa ordinary persons tungkol sa batas at sa buhay. Okay? Bye-bye everyone. Good luck and God bless you.